There are 5 mistakes that can make your entire estate plan fall apart, and most families don't find out until the people they love are already stuck dealing with the mess. In this video, I'm going to walk you through each one so you know exactly what to look for and how to make sure your plan actually protects your family the way you intended. Hi, I'm Stephanie Padley-Julian, founder of Padley Law. As a mom myself, I understand how important it is to protect your children, your home, and your legacy. For over 15 years, I've helped families across Florida create personalized estate plans that give them the peace of mind they deserve, knowing their loved ones are cared for no matter what. If you're ready to protect your family's future, I'm here to help. Call us today at 239-963-6043. The first mistake is thinking a will is the whole plan. When you finally sit down and write a will, it feels like a huge weight off your shoulders. You picked guardians, you made your wishes clear, and you feel like your family's taken care of. But here is what most people don't realize. In Florida, a will is actually a set of instructions for the probate court. So that means that after you pass, your family still has to go through court process. A judge has to validate the will, debts have to be settled, and then everything gets distributed. That process can take 12 to 36 months and sometimes longer. And during that time, your family may not be able to access accounts, sell your home, or move forward. And the bills don't stop. The mortgage does not pause, and life keeps going, and your family is left waiting and paying during that time. But here's the part that really catches family off guard. A will only takes effect after you die, so it does nothing if you are alive but unable to make decisions. If something happens to you tomorrow, an accident, a medical emergency, something sudden, your family may not be able to step in and handle anything. Not your bank accounts, not your medical care, nothing. And I know that's a scary thought, especially when you have kids depending on you. So a will is a good start, but it's just one piece of the puzzle. It's not the safety net most parents think it is. Now, even families who go further and set up a trust can still get caught by the next mistake. And honestly, this is one that breaks my heart the most, because these families did the right thing. They invested in a plan. They sat down with an attorney. They signed everything, and it still didn't work. So the second mistake is creating a trust, but never funding it. And here's what that means. A trust is like a container that is designed to hold and protect your assets. But if you never actually put your assets into it, that container stays empty. It exists on paper, but it does not own anything. So if your home is still titled in your personal name or your bank accounts were never retitled, those things sit outside of the trust. And when something happens, they don't get the protection of the trust that you are supposed to provide. Your family can end up in probate anyways, even though the trust exists, simply because the assets were never connected to it, never moved into it. And I know that sounds frustrating, and it is. So funding your trust means that you're going through your accounts, your property, your investments, and making sure everything is titled correctly so that the trust either owns the asset or is a beneficiary of that asset. We want everything flowing through it at some point. It means updating the deed on your home. It means checking that your accounts line up with the plan. And it's not a one-time thing. Every time you buy something new, open a new account, or make major changes, it needs to be connected to the trust. I know that sounds like a lot, but it's the step that makes the difference between a plan that works and a plan that leaves your family in court. And even if you get that part right, there is still one more thing that can quietly undo everything. And most families have no idea, and it is sitting there. The third mistake is ignoring beneficiary designations. So these are the forms you filled out when you open a life insurance policy or retirement account or certain bank accounts. You write down a name, and that person receives the money directly when you pass away. Here's the thing. Those forms do not follow your will. They do not follow your trust. They act like their own separate contract. So whoever is listed on that form gets the money, no matter what your other documents say. And the problem is that most of us fill out those forms once and then never look at them again. But life changes. You get married, you have kids, sometimes there's a divorce, and that old form just sits there with a name on it that may no longer make sense. When the time comes, the money goes exactly where that form says, and even if that's not where you want it to go. So if a child is named directly, the family may need to go through a court process as well, just to get someone authorized to manage those funds for the child. So please pull out your beneficiary forms and look at them. Make sure they match your current plan. Make sure you have backup names listed. And check them again after a big life change or every 1 to 3 years. That one step can save your family so much confusion and heartache. Now, the first 3 mistakes are about paperwork and setup. But this next one is about something that happens in families all the time, and it feels like enough, but it is not. So the 4th mistake is relying on verbal agreements instead of legal documents. And I understand why families do this. You sit around the table, you talk about what you want, and everyone agrees. You tell your sister she will take the kids, you tell your parents how you want things handled, and it feels settled. But in Florida, those conversations do not carry legal weight. So when a real emergency happens, banks don't accept the conversation as authorization. Hospitals follow whatever is in the legal paperwork. And if there is no paperwork, your family may be left without the ability to do anything, even if everyone in the room knows exactly what you wanted. And here's the harder truth. When emotions are high and stress is through the roof, people remember conversations differently. What felt like a clear agreement at the dinner table can turn into a disagreement pretty fast. And once that happens, it doesn't just create confusion. It creates conflict between the people you love the most. So that is the last thing any of us want for our families. Every important decision, who raises your kids, who handles your money, who makes medical calls, needs to be written down, signed, witnessed, and notarized under Florida law. I know it feels formal, but that formality is what gives your family the power to actually act when they need to. And without it, love and good intentions are not enough to get through the legal system. Now, this last mistake is the one that most families never think about. And honestly, it's the one that keeps me up at night as a mom, because it is not about what happens after you're gone. It is about what happens if you're still here, but you cannot take care of things for yourself. The 5th mistake is only planning for death and not for incapacity. Most of us think about estate planning as something that matters after we die. But the situation that hits families first and hardest is when someone is alive but unable to make decisions. That could be after a car accident, during a serious illness, after stroke, or because of complications from a surgery. And it can happen at any age. And if it happens and there are no documents in place, your family may not be able to pay your bills, deal with your insurance, make decisions about your medical care, or even keep the household running and take care of the kids. And I know a lot of married couples assume that a spouse is just going to step in and handle everything. But in Florida, marriage alone does not automatically give your spouse legal authority over your finances. Your adult children cannot step in either without the right paperwork. Without a durable power of attorney, your family may have to ask a court for permission to help you. That takes time, it costs money, and while that process plays out, the bills keep coming, the kids still need everything they need, and your family is stuck. So a durable power of attorney takes care of the financial and legal side. A healthcare directive and living will take care of the medical side. And together they will give the people you trust the ability to act right away instead of waiting on a court. But here's the important part. These documents have to be in place before something happens, because once you cannot sign, it's too late to create them. That's the mistake most families do not see coming. And as a mom, it is one that I want every parent to fix first, because your kids need you to protect them right away, now, not just someday. So if you're a Florida parent or grandparent and you're not sure whether your estate plan has any of these gaps, I want to help. Please call me at 239-963-6043. We'll sit down together, we'll look at what you have, and make sure your plan is actually going to do what you need it to do for your family. And now that you know what can go wrong, the next step is knowing exactly what belongs in a complete estate plan so nothing gets missed. In my next video, I'm going to walk you through every document and every decision that should be part of your Florida estate plan. Click here to watch it now.